So hi everyone, thank you for joining us today, and thank you, John, for speaking. It's great to have you. I believe this is your first time speaking at one of our events, right?
It is indeed.
Well, it's great to have you, so thanks for joining us today.
Thank you.
So John Hyde is the managing partner of Hyde HR Law. Centered in the GTA, Hyde HR Law represents clients across Canada, from multinational corporations to small businesses, from individuals to groups and associations. John advises management on all aspects of employment and labor law, including representation before administrative tribunals, collective agreement negotiation, arbitrations, wrongful dismissal defense, and human rights. He also assists clients in providing strategic, legal, and human resources advice on labor and employment matters arising out of complex mergers, acquisitions, and the sale of businesses. John's pre-law background is in operations and human resources management, providing him the unique opportunity to assist clients in the formulation of practical legal solutions specifically tailored to their needs. Thanks again for speaking today, John, and good luck with your presentation.
Thank you so much. So I want to talk a bit about the COVID pandemic and what's in store for the future. Of course, the COVID pandemic has been hard upon everybody. Lives have been lost. Businesses have been lost. Businesses have either shut their doors permanently or been faced with bankruptcy. And many of those still operating continue to do so, treading water with the help of government financial assistance, such as CEWS, loans, and the like. Now, after 3 waves of the COVID-19 pandemic, Ontario is finally seeing light at the end of the tunnel. Even today, Ontario reported only 411 cases of COVID-19, the lowest case rate since September of last year. That's very good news, of course. But what happens as we move into the post-pandemic business environment? What will that look like? Assuming government assistance has ceased or otherwise dried up, how will businesses stay afloat as consumer confidence very slowly, perhaps too slowly, increases? In fact, not yet confident about the short-term economic recovery, the Bank of Canada announced today that would hold the benchmark interest rate at a historical low of 0.25%. And interestingly, the comments from the Bank of Canada are even more cautious than they were in April of this year when it last considered interest rate projections. In short, there are a lot of unknowns for post-pandemic business environment in Ontario, and in fact, in every province. From a business perspective, there will be both winners and losers. With that, however, and for those businesses who have remained solvent, whether through good luck, good planning, or simply being in the right place at the right time, many will be looking to grow, whether through mergers, acquisitions, and the like. Your clients will more than ever be relying upon your advice and guidance to make the right decisions at the right time and for the right reasons. There will be many opportunities to purchase businesses and assets of those businesses that simply, sadly, just could not successfully survive COVID-19. And at the front line of helping every successful business to succeed, the CPA is the first line of defense, in my view, protecting clients from liability, both known and unknown. And as a trusted financial advisor that helps individuals, businesses, and other organizations plan and reach their financial goals, you, the CPA, are in a unique position, in fact, far ahead of lawyers, to be able to understand your client's business, the growth of that business, and help plan for the future. Notably, your clients also come to you for sound advice and business due diligence, particularly when they're considering opportunities for growth. However, business due diligence has never been more important than it is today. Residual liabilities from failed businesses can be enormous, sufficiently so to warrant taking an in-depth look at every opportunity long before your client even buys into it. One of those liabilities is that of union bargaining rights. So imagine this. Your client is looking at the purchase of a meat processing and retail business. I'm just using that as an example. The business that is looking at went bankrupt a year and a half ago, perhaps because it was already underwater at the start of the pandemic. Your client decides to buy the assets of the bankrupt business from the trustee in bankruptcy because it'll provide your client an opportunity to grow its business, perhaps covering a line of products that it did not do so previously. Your client completes the purchase, spends $1 million or more in upgrades and refurbishing. Employees are hired, including some of the employees from the previous business, simply because they answered ads and sent out online applications. Your client did not go out specifically looking for those employees to hire. Your client then becomes operational, is doing well, and through your good management and your support and guidance is turning a profit. 8 months later, there's a knock on the door of the business. A gentleman introduces himself and hands your client's management a business card that says he's from Local 175 of the United Food and Commercial Workers Union. He then tells your client that his union has bargaining rights for all of your client's employees at the location. And by the way, because it did not hire all union members, your client is liable for lost wages, vacation pay, benefits, including pension benefits, as well as union dues. Your client says, wait a second. All we did was buy the assets of a bankrupt business through the trustee. The union representative responds, well, that may be so, but you're deemed a successor under Section 69 of the Labor Relations Act, and your obligations under the existing collective agreement began the day you bought the business. Sadly, this is a real example. Even more sadly, it's a situation that continues to repeat itself, not only throughout Ontario, but across Canada. All provincial jurisdictions and federal jurisdictions, for example, that under the Canada Labour Code, which covers such things as railroads, cross-border trucking companies, shipping, airlines, telecommunications, have successor rights legislation to protect unions and union members where there's a sale of a business. But wait a second. Doesn't the sale of a business really mean the purchase of the majority of shares of that business? The answer is no. More often than not, successor rights legislation covers asset purchases. And this does not matter if the asset purchase is made through a trustee or receiver. So we'll start with a short primer on Ontario legislation. But again, as I mentioned, every jurisdiction in Canada has the same kind of law. Section 69 of the Labor Relations Act states in part, and this is important. In this section, it says, business includes a part or parts thereof. Sales includes leases, transfers, and any manner of disposition, and sold and sale have corresponding meanings. It then goes on to say where an employer who is bound by or is party to a collective agreement with a trade union or council of trade unions sells his, her, or its business, the person to whom the business has been sold is, until the board, and that's the labor board, otherwise declares bound by the collective agreement as if the person had been a party thereto. Now, there's a couple of things that are very important here. First of all, the legislation says that the determination of a sale is broadly defined and can include sales, leases, or transfer, or in any manner of disposition, transfers such things as assets. Clearly, this is not just a share transfer. Secondly, the purchaser stands in the shoes of the original party that was subject to the collective agreement with the union. And thirdly, the obligations under the collective agreement, whether current or expired, take effect the minute the sale is completed. Therefore, the liability starts upon completion of the purchase, whether or not this was an asset purchase. Do all asset purchases represent a sale of business under the Labor Relations Act? The answer is no, but here's where it gets tricky, and it becomes a question of both law and fact. Section 69 of the Labor Relations Act is what you call successor rights protection. It protects a bargaining unit, that is the bargaining rights of the unions and the employees represented by those unions where there's a sale of all or part of the business. The key is it has to be a business that is transferred. So the question becomes, what constitutes business? The Ontario Labour Relations Board and the courts have described it this way, and I'm quoting from one of the main decisions, and that is, a business is a continuation and combination of physical assets and human initiative. In a sense, it is more than the sum of its parts. It's a dynamic activity, a going concern, something which is carried on. A business is an organization about which one has a sense of life, of movement and vigor. It is for this reason that one can meaningfully ascribe organic qualities to it. However intangible this dynamic activity and the quality, it's what distinguishes a business from an idle collection of assets. Another position put it this way, In deciding whether a transaction amounted to a transfer of business, regard must be had to the substance rather than its form, and the consideration must be given to the whole of the circumstances, weighing upon the factors which point one direction against those which point another. In the end, the vital consideration will be whether the effect of the transaction was put to the transferee in possession of the going concerns. So that decision goes on further and says, in the absence of an assignment of premises, stock and trade, or outstanding contracts, will also likewise not be conclusive. So what they're saying here is that the board will look at all factors to determine whether or not there's been a sale of business, whether sale of shares or a sale of assets. And really, the board will not look at form over substance. It'll take an in-depth approach to this. So what does all of this mean? It means that a sale of business for the purposes of the Labor Relations Act can include an asset sale, provided the purchase of such assets allow the purchaser to carry on substantially the same business as before. Now, this also includes goodwill. For example, let's say your client purchases a retail establishment that was previously unionized. It does not matter what it sold prior to the business, in any prior business. It can be groceries, it can be widgets. Apparently, they're quite popular. It can be the provision of services. Your client bought all the assets of the business, but did not employ any employees. But because your client likes the location, it is perfect. The problem is the labor board has found that successor rights attached to location-based goodwill. The theory is simply this: because the prior business drew its customers from the surrounding community, goodwill attaches to the location. And therefore, because your client has purchased or even leased the assets of the location, including real property, any prior bargaining rights and collective agreement that exists now apply to your client. Now, the next question becomes, does every asset purchased from an existing or bankrupt unionized business constitute a sale of business under the Labor Relations Act? Well, the answer is no. Take, for example, a case of Woodland Store Fixtures versus United Brotherhood of Carpenters. This is quite an interesting case because Woodland was a store fixture business that ceased operating in May 2011. Another company, a competitor named Wood Branch, was also a store fixture operation. Wood Branch grew rapidly and subsequently acquired the rights to the Woodland former premises. And I'm sorry, I can't change the names. These are the names, although they sound rather similar. What really happened here is that Wood Branch ended up getting the building and certain machinery, assorted materials, and vehicles. And among those things, it should be noted that the acquisition did not include any customer lists, trademarks, or accounts receivable. It ended up that many former employees of the ceased operation went to work for Wood Branch. Now, the union asserted that Wood Branch had acquired enough of the assets and employee experience from the ceased operation that it constituted the sale of business under the Labor Relations Act. Wood Branch took the position, as it should, that it purchased merely idle assets of a defunct operation and not a business. The decision noted in part, the board must examine whether a dynamic, going concern, or functional economic vehicle has been transferred from Woodland to Wood Branch. The board found that none of these factors existed. The ceased operation was a moribund business. It had shut down its operation. Most employees had been laid off, and there were no clients transferred. Wood Branch was a new business which had acquired the premises, not the business of the ceased operation. And then the board went on to say that acquiring valuable assets and hiring skilled employees from a pool of unemployed workers was not the same as acquiring a business. There are a couple important points to this decision. Firstly, the purchaser was to Woodland. The purchaser was simply trying to expand its business, not acquire a dynamic business activity. There was no agreement to hire employees of Woodland. Ultimately, many did get hired, but through a general application process. They were not specifically solicited by the purchaser. Further, the type of business undertaken was not reliant upon location. It was not a storefront type of business that attracted customers within the community. Therefore, there was no location-based goodwill. So in the end, the Labor Relations Board determined no sale of business occurred under the Labor Relations Act. Now, as I noted previously, it does not matter that the assets of a business are purchased through a trustee or receiver, and this is very important. Bargaining rights flow through bankruptcy and bind the successor purchaser. They can also bind a receiver running the business prior to the sale. 2 months ago, the Ontario Superior Court of Justice Divisional Court rendered its decision in Deloitte Restructuring versus United Food and Commercial Workers Union Local 175. This was an application for judicial review. It's sort of like an appeal of a prior Labor Relations Board decision, which had found that Deloitte Restructuring was a successor employer within the meaning of the Act. Here are the facts and law. The receiver had been operating the insolvent business retirement home for several years. The board then examined the relevant provisions of the Bankruptcy and Insolvency Act, we'll call it for short the BIA, to decide whether the provisions precluded a finding that the receiver was a successor employer. The board and subsequently divisional court noted that the history of jurisprudence, or the case law, if you will, respecting those provisions are clear. And this is what they said. Receivers were not liable for pre-appointment liabilities or post-appointment liabilities that accrued pre-receivership. But a receiver who operated an insolvent business may be found to be a successor employer under the BAA and thereby subject to the collective bargaining rights of the employees prospectively. Based on those findings, the board found that the BIA did not preclude the requested declaration that the receiver was a successor employer. The court noted that bargaining rights were not liabilities within the meaning of the BIA and may be properly understood as vested rights. Why is that important? Well, as a successor employer, a trustee is generally going to be bound by the existing collective agreement and would have continuing obligations arising from the certification of that collective agreement, even if the agreement had expired. And in this case, the labor board, and of course with the divisional court's approval, ordered the receiver to enter into collective bargaining negotiations with the union. So it's clear that a receiver can be a successor employer. Purchasing from the receiver, you become a successor employer as well, your client rather, and must be managed. There's a couple of takeaways from this. Firstly, a successor employer and successor employer bargaining rights flow through a trustee in bankruptcy or a receiver. Secondly, even the receiver operating the business can be found to be a successor employer under the Bankruptcy and Insolvency Act. Thirdly, and as I noted previously, successor union rights can even attach to a sale of assets, provided the purchaser is given the opportunity to take control of a dynamic business opportunity. And always keep in your minds the importance of that dynamic business activity. And what does that mean to you? It's simply about due diligence in the process of purchasing a business. And it's particularly important that the due diligence is significant. You do not necessarily know whether a business that your client is interested in purchasing, and that your client might be a corporation that you work for, is or has been unionized. And I have to tell you, even corporate commercial lawyers often miss this because it's not part of the regular due diligence process. In fact, we've been brought on to act in many cases to defend purchasers against unions claiming successor bargaining rights. Now, it doesn't have to be that way. As I mentioned, CPAs are in the unique position to assist their clients when they're looking at the purchase of a business or assets of a business. They play a crucial role in helping your client avoid union liabilities. And I hope that assists you in taking a look at the kinds of things that become more important. And let us not forget, as companies have hurt, so have unions. And so unions are on the lookout for opportunities to recover, if you will. And part of that recovery is going after companies that purchase defunct businesses or the assets of those defunct businesses. So stay on guard, use strong due diligence, and when in doubt, you can seek legal counsel to assist. I think that pretty much completes my presentation, but if you have any questions, you're certainly welcome to contact me. My email address is jhyde@hydehrlaw.com, or you can contact me on my direct line at 416-309-0036. Thank you.
Hi, John.
Hello.
Hey, I just wanted to jump on quickly because it doesn't seem like we have any questions, unfortunately. If anyone is watching, please just put a message in the chat here, or sorry, your questions in the chat here, and we'd be happy to address them. But in the meantime, I just wanted to ask, what's the key takeaway, or maybe the top 3 things that you want someone to get from your presentation today?
Well, firstly, that union bargaining rights are a hidden liability. You don't necessarily see it when you're looking at a normal transaction, particularly a transaction which is somewhat insulated by going through the process of bankruptcy or being sold through a receiver. And because of that, it can be a real problem, particularly with an example I gave you, where all of a sudden the deal is done, the company is actively carrying on business, and the union comes knocking, and that's a real problem. The only way to avoid that is through good due diligence. And what I ask people to keep in mind is always think, was there a union there in the past? And sometimes maybe no one has heard from the union for 6 years or more, and the union still may claim bargaining rights. And really doesn't matter. You know, it's not just about the union being successful in that. It's about the litigation, the cost of that litigation that CPA clients will have to incur even defending that kind of action. And the cost can be significant. Some companies have paid hundreds of thousands of dollars in dealing with matters before the labor board. So it's really important to be on guard and to be proactive. It's all about due diligence.
Okay, great. Yeah, so I don't see any questions here, unfortunately. I know you mentioned some contact information for people to reach out to you.
Yes.
You're on LinkedIn as well, correct?
I am indeed.
Okay, great. And that's the best way for people to reach you?
Either my email, again, jhyde@hydehrlaw.com, or otherwise you can call me directly, 416-309-0036.
Okay, great. Well, thanks again for your presentation today, John. It was really great. Lots of great information. So just to let everyone know, so our next set of sessions starts at 2:50, so there's about 12 minutes left. So feel free to visit the networking area, which is over on the left-hand side, and you can get into some sort of one-on-one video chats with people. Thanks again for your presentation, John.
Thank you. Take care.
Thanks. Bye.
Bye.